Well, welcome to everybody. This is a continuation of a series of history seminars, although not focused as much as on Native Americans, but here we're taking on the subject of land and water. And I'm very pleased to introduce a longtime friend and colleague, John Ferejohn, who will be speaking today on a study he's been doing, a book indeed he has on exactly the subject of California water. John is currently the Samuel Tilden Professor of Law at NYU, but he's also Professor Emeritus, a political scientist here. John started out actually working on some issues of water in his initial book, Pork Barrel Politics, which was published here at Stanford in 1974. He's a co-author on a book with me called The Personal Vote, which is cited typically as Bruce Kane et al. This is et of et al. Right here. That's his pen name anyway. And he also has written a book called The Republic of Statutes, which has actually been a very influential work in legal scholarship. After John speaks for 20 or 30 minutes, we hope 20 or 30 minutes, we will go to our next speaker, which will be Phil Womble, assuming we can get him online. He's online, good. Phil is a recent PhD here in the IPER program and also a JD in the law here, and did his undergraduate work in environmental studies and has written about the Colorado water problem issues and knows quite a bit also about California water. And then we're going to come in with another colleague of John's, Roger Knoll from the economics department. Roger is a professor emeritus of economics, but he's the founder of the public policy program here at Stanford, and he and I have been doing some work recently on California energy. So I'm going to hand it over to John, who will kick us off with the politics of land and water.
Thank you. That was more than I expected. Anyway, this is, I'm glad you could all join me here, and those who are online. Thank you very much for coming. Thank you especially those of you who actually read the whole thing that I distributed, which is 150 pages long and which needs comments. So if anybody feels the urge, having looked at any part of it and wants to send me comments, I'm more than open to suggestion. So what I'm presenting is part 2 of that manuscript. The manuscript is pretty long. This is part 2 has to do with what I call politics of land and water. The larger study is a study of groundwater in California from the beginning to the end. The beginning is several million years ago when groundwater started. There was a lake here, it sunk, so that's a short story. In the first part of the book outlines the problem, and there's a few slides at the beginning that are going to show you the kind of problem I'm talking about. So this gives you a sort of, this is the Central Valley, California. There's 3 kind of big mega basins, the Sacramento Basin, the San Joaquin Basin, and the southernmost basin, the Tulare Basin. They are ordered in order of dryness. The Sacramento Basin is fairly humid sometimes, and the Tulare Basin is basically a desert in terms of its climate and rainfall and things like that. So this is groundwater from 25 to 2010 really. There's more recent versions of this picture which will appear eventually, but they tell the same story, which is to say that you see the problem is not at Sacramento. It is to some extent in the San Joaquin Basin, and it's really severe in the Tulare Basin. The Tulare Basin is the location that you've been reading about lately in the newspaper about Lake Tulare, which used to be the largest lake in the United States west of Lake Superior in the 19th century, and then it disappeared over the course of about 60 or 70 years, except for in very wet years. This is one of those wet years. It's back, right? So the Tulare Basin is an extremely fertile area. It was, underwater for a long time. It's full of organic materials. It's very good farmland. It's very flat, very easy to farm, if you can manage water. So anyway, so that's what's happened over time. The groundwater levels have declined a lot. The second thing that's important is this. This is a rough picture of wet and dry periods in California. You see they alternate, kind of. And this is the overall picture, I guess, probably it's aggregated those 3 graphs before. So it's what's happened to the water table. You can see in wet periods, there's a slight recovery. That is in terms of the water table goes up a little bit, like over here and here and here. But the bumps are small and they don't recover, right? So that while there is some recharge from wet years, it doesn't really fix the problem at all, right? So the overall story is still what was in the first table, which is a severe decline in Tulare Basin and a moderately severe decline in the San Joaquin Basin. Okay, the third picture is recharge recovery. This is measuring what's happened to the water table actually in more detail, again from 1960 to 1996, but the 1960 is like the beginning of the sort of modern period of California water, where there's a lot of deliveries from the Central Valley Project and when the state project hasn't come online. The state water project began coming online around here, and you see there's more recharge from surface water into the water tables in that period. So the problem is what to do about that. It seems clear from everything that the problem is that exacerbated by climate change. It's also clear, as I'll talk about in a little while, that the problem is that surface water is becoming more scarce and difficult to get for farms. And when farms don't have surface water and they want to continue farming, they have to use groundwater, right? So that's a rough generalization. So what's happening is this is agricultural use basically driving the decline in especially the Tulare Basin, but throughout the valley. So, all right, let me say a few summary. This is all from part one. Part two, I have a description of water law, and I'll just say briefly, in case you don't know, some of you don't, I'm sure, about the principles of water law in California. There's historically, there's two systems. One is called the riparian law system, and the other is called the appropriations principle. The riparian doctrine, which is the idea that if you own land adjacent to water, you have a right to use the water. There are historically a lot of restrictions historically on that usage. That is to say, historically you're not supposed to use it for irrigation. That's sort of fallen away. In effect, you're supposed to use it and return the return flow back to the water source. There's many other limitations on the use of riparian rights, but that's one source of water rights. The second source is appropriations, which is the first person to come and divert water from a stream and to do it in a notorious way, that is to sort of post that that's what they're doing, has a right to whatever they claim, including in principle the right to the whole stream. And that principle was established de facto in the minefields when within a year or two of the discovery of gold, it became necessary to use vast quantities of water to mine. First through sluices and things like that, but more importantly, once the easy pickings were gone, it was necessary to blast away hillsides and expose strains, and the only way practically to do that was to use water pressure, which meant diverting sufficiently large quantities of water to have reservoirs up high and pressurize a hose and blast it away. So that was the principal way in which mines were operated after about 1853 or 4. So that was, and so what happened was that when people would have a place where they thought there was gold, they would find water sources and they would claim the stream by appropriations, and they divert the whole stream, And so, there's lots of dried stream beds there that were essentially commanded in that period. Some of them rewatered after the mines weren't working, but that's basically the way that works. There's a third principle that's increasingly important over time, which is prescription, which is when the rights to a water source are fully claimed, right? Which there's technical words for it. When it's fully claimed, somebody can attempt to establish a prescriptive right to the water by simply taking the water, notoriously and publicly. And if it's not challenged by an existing rights holder, that will ripen eventually into a right to take the water of the same quality of appropriations. And that's an extremely common form in urban areas like in Southern California, which I'll talk about briefly a little bit later. So groundwater law is a little bit like surface water law, except for the fact that the adjacent water is down below. All right, so until about 1900, in a famous court case, the right of an overlying landowner to the water beneath his property was absolute. It was absolute in two senses, which is to say that he could use the water any way he wanted, and there were no restrictions initially on how he could use it. So he could just, he could sell it, he could alienate it. A riparian user could not sell the water outside the basin, That would be illegal. An appropriations unit could do that, but there'd be other restrictions on our appropriator's right to water for surface water. But with groundwater, there were no restrictions initially. And then, in the second sense was, so it's a little bit like a riparian right in the sense that your right comes from adjacency, but the difference is there's few restrictions on what you could do with the water. In fact, effectively, you could do anything with the water initially. And then there was a presumption throughout the 19th century that water, with exceptions, water underground didn't move, right? So the exceptions were underground streams and rivers. So for example, in Los Angeles, there's a thing called the Los Angeles River, which mostly runs underground. That was understood to run underground. So if you were drilling, on the Los Angeles River from above and took the water, it would be understood you're having an effect on downstream people, right? But aside from moving waters, the presumption in courts were water down below does not move, right? And that was enshrined in various ways in law, but effectively what it meant is that if you thought your use of water was impaired by somebody else's drilling a well, the burden of proof was on you. And that is a very high burden of proof given the knowledge that you could have about what's going on underground, at least the way the science was until pretty recently. So it meant that overlying landowners had a right that was extremely valuable to them, especially in land that I just talked about, the Tulare Basin. That is, the Tulare Basin is basically a desert. If the way you get water there is either there's a few streams that empty into it. They are the Kings, the Tule River, the Kauai River, the Kern River. None of those go to the sea. They terminate in the Tulare Basin. Once that water was claimed and used, which is the way the lakes were drained, there was no other regular source of water other than rainfall, and the rainfall there is and annual flood from the Sierras and rainfall, which is running about 6 inches a year. So it's not much. So that meant that in dry years or in dry periods of years, you had to use groundwater, and so this right became extremely important to the landowners there. So that's, and the thing about groundwater in addition, which is obvious when you think about it, is that it's hard to tell what people are doing with it. That is, people can drill surreptitiously, they can take water. There's very limited monitoring capacity historically. That's changing recently, mostly because of satellite technology, which allow you to measure ground movement to a great precision, so we can sort of infer what's going on underneath. But until that came online, which is about 20 years ago, it was very difficult to monitor many areas. And so the right the landowners had to underlying water was jealously guarded, and there was opposition to every state attempt to cut into that right there still is opposition to that. All right, so, one more comment, which is that what happened in the course of the 20th century is the drills and pumps became vastly more powerful, and more accessible to people. So that meant that you could drill for water much deeper than was possible in the 19th century, which meant the pressure on the water table was much greater. I'm not going to go into detail about that unless there's questions, but that had a lot of implications for the structure of water tables in the area. So, regulation of water rights, well, initially they weren't very well regulated, but the general principle was the riparian rights were superior if they were established prior to appropriation claims. So for example, this happened actually frequently in the Central Valley. Henry Miller was a rancher who established an enormous ranch in the 1850s and 60s. He owned about 150 miles of frontage of the San Joaquin and many other places. He had lots of riparian claims. And so people would attempt to divert water upstream from him, all right? And they were appropriating water, and his ownership of the riparian claim gave him a superior right. So he could get an injunction for people to stop the diversion if they tried to if they impaired his right. And that was a common situation. Riparian rights are also ordered in order of claim. So if somebody, person A, diverts a part of the stream for their own use, they have the first, and let's say they're the first user on the stream, there's no riparian rights upstream or downstream. They have a right, if somebody else comes in and claims the rest of it, they have a second right. If the flow of the stream is adequate to fulfill the first person's claim but not the second gets nothing. All right, so the ordering is lexicographic. The first claimant gets a claim to all the water of his claim, and then the second person gets whatever's left over, and the third person if there's anything left over, et cetera. So the rights claims are by seniority, which means, and so let's say the first person is called a senior claimant. And so in California water law, as of 1913 or so, senior claimants are considered to be riparians or first appropriators. After that, everybody else is a junior claimant, right? So another feature of the Central Valley, the Tulare Basin, is almost everybody's a junior claimant. Almost no one has riparian rights there anymore. So I should say one more thing about riparian rights, which is your right to the water comes from being adjacent to the stream. If you sell off any part of your land, the only part of the land that has any riparian right is the part that remains adjacent. The other part can never reclaim it, right? So, if you just divide, you sell off the part that's not stream front, it has no riparian right at all, right? So that's another feature of riparian rights. All right. So political problems. So in 1850 with statehood, in principle, California was divided into land that was previously owned and land that wasn't owned. The land that wasn't owned in the doctrine established in the Northwest Ordinance was held as public domain by the federal government, right? So, but there were lots of lands that were previously owned. Some of it were held by Indian tribes, but a lot of it was held in the form of ranchos that had been granted by the Spanish and then the Mexican governments. And it was about, I want to say, 9 or 10 million acres of land of that form. And a lot of the land in the Central Valley was owned in that way. But for the most part in the Central Valley, this area, the Tulare Basin, the San Joaquin Basin, was mostly a swamp at that point, at statehood. So the lake was there, it was a lake, and then all around the lake were tule things and swamps. And so it was, mosquito infested. There were Indian tribes that were there that exploited what the lake had, which were fish and game and things like that. But it was a swamp. It was very difficult to do much with it initially. But Henry Miller, he was a German, but a German butcher, acquired a lot of land there. And he did what the Mexican ranchers had done before him, which was you just turn cattle loose to do the best they can in the swampland, and they eat then, and then once a year you round them up and drive them to market. And this was done, by the Mexicans for 50 or 60 years before California statehood, and this is what Henry Miller did. And anyway, so then then the gold rush is happening, at statehood. It's been going on for 2 years when statehood is granted, and a lot of people come for the purpose of seeking gold or their fortunes, either by ship or by overland. And if they came, however they came, they rapidly found out that it was hard to get gold. So people went into other lines of work. And so you can think of there being 3 streams of immigrants. One were people, who came, let's say 2 streams of immigrants. People who came, 3. One stream came for the gold. One stream came to take advantage of what the gold economy would provide, which is dry goods merchants, basically. People would sell stuff and supplies, or do services. And then the third is people who had political ambitions, that is, who were, for various reasons, unable to fulfill their political ambitions elsewhere. So one of the chapters that you have, it has to do with people with political ambitions. And this set of people came, like one of them was William Gwynn, who was the first California senator. He and John Fremont were the first senators, and he was the senior seat, so he got a 6-year term in 1850. And he had been a congressman in Mississippi. He was a lawyer and a doctor. He held slaves in Mississippi. He had a plantation with at least 20 slaves when he started. I think he ended up with several hundred. He had that plantation around Vicksburg all the time he was in California from California as a senator. He was a major speaker, maybe the major speaker in the California Constitutional Convention, and advocated strongly that California be admitted as a free state, that is, it forbids slavery. So he didn't believe it for a minute, but that's what he advocated because he had a political ambition to become a senator. So that's an example of somebody who comes from someplace else. He was a congressman in Mississippi. He got in trouble with a local senator. He left because he had no Mississippi future. Another one was David Broderick, who was from the Tammany Hall, basically in New York. He ran for Congress. He was blocked by rivals in Tammany. he saw his political future blocked. He sold. He was a fire captain, a Democrat. He basically gave that up and came to California and started his career in California, and he became a senator in the middle of the 1850s. So those are examples of people who come for political reasons, for careers. And among the second stream, the people who are going to service the miners, but who are not going to be themselves miners, were Leland Stanford, Charles Crocker. I mean, all the big four. Those were all dry goods merchants from the burnt over district of New York. So this is a stream of people who come for other purposes, and some of them end up with political careers, but they came not for political careers particularly. One important person who came in that early period was Stephen Field, who was the younger brother of David Dudley Field. David Dudley Field was a prominent know-nothing in New York, and a lawyer, a very distinguished lawyer, and he was the inventor of what was known then, actually, and it's still known, as the Field Code, which is a codification of essentially a common law system. And he was a proponent of the Field Code from the 1840s. His brother was 10 years younger and worked in his office. And when he came out to California, basically probably because David Dudley was a bit overbearing, and he wanted to have his own career as a lawyer. He came to California, went to Marysville, and established a practice. He rapidly was elected alcalde, which means judge magistrate, and was enforcing, incidentally, the mining codes in California. But then he got into political trouble with a local rival on the bench and ended up running for the state senate. And while in the state senate in 1851, he introduced the Field Code, because he had a copy, into California law, and enacted a version of the Field Code in California in 1851. And then later on, he became Chief Justice of the California Supreme Court, and then later on, in 1863, he was elevated to the U.S. Supreme Court, where he served for 30 years. So, and I'll go back in Q&A maybe, what his significance was in the structure of American law. But I would say, if you think of the evolution of the jurisprudence in the late 19th century, especially the movement in the direction of enshrining private property as a specially constitutionally protected element of American law, Field was the proponent that pushed it furthest and farthest. And I think most of it came from his California experience. So that was the second stream. So the problem, the early California problem, was that a lot of the land was already claimed. Either it was in these Mexican and Spanish land grants, or claimed by Indians, or held in some other way by somebody who got there first. And the people who got there first were people like this person, Henry Miller, or his adversary, James Ben-Ali Hagan, or Lloyd Tevis, who was the chairman of Wells Fargo. And I mean, these different people, they were able to grab up huge quantities of land because, essentially fraudulently, because they used what are called dummy buyers. They would have people who had a right to buy a small quantity of land, and then they would use those people, through a broker usually, to accumulate large quantities of lands from dummies that would be transferred to them as a unified holding. So that these, and there were other forms like that. So for example, there was a piece of legislation that had been on the books for a while called the Swamplands Act that was enacted to deal with issues of swamp drainage in Louisiana and Arkansas in the 1840s. But then it applied to the Tulare Basin also. So Henry Miller used the Swampland Act to acquire swamplands, which he otherwise would not have been able to buy. And he did it by promoting the fiction that it remained a lake after it stopped being a lake. So he claimed to have traveled from the bottom of the Central Valley to the top in a boat. And the way he did it is he put his boat on top of a wagon and had the wagon drive from the bottom of the Central Valley to the top. So that was the basis of his claim, so it said, to use the Swampland Act to acquire land. So he acquired at least 1.5 million acres in California. His rival, Ben-Ali Hagan, acquired, I think, about another 1 million. There were several other people that were holding in the millions. So when people came overland to seek their fortune and found out that the gold fields were not a way to get rich, and they went to try to establish homesteads someplace in the state, the land was taken up, right? And another feature was some of the Mexican land grants were what are called floating grants, so that the grantee would receive a right to, I forget the unit now, but it amounted to about 80,000 acres of land, but the boundaries weren't fixed or surveyed, right? So they had to be fixed in a subsequent survey. The most famous case of that was John Fremont, who was the second senator in California, bought what is called the Mariposa Grant, which is about 80,000 acres, and he bought it in the late 1840s, and then gold was discovered nearby, or maybe on the grant, it's not clear. But Fremont himself surveyed the grant and said, oh, the boundaries are such that they include the gold discovery, right? So then enormous amounts of litigation followed on that, which is described in the papers you have. And ultimately he ended up winning and being able to eject alternative miners who actually had been establishing claims in that area. But he, established that his claim to the floating grant was sufficiently persuasive that on a resurvey, he was able to prevail. So that's an example of, somebody coming overland, let's say, or being discouraged in the gold field, wanting to establish a farm, finding out that he was not in time. So they would have incentives to take advantage of that situation if they could, which was to squat and establish, try to do some improvements, build a house, build some fences, start planting stuff, hope, do it in a notorious way, and hope whoever has a superior claim or claims to have a superior claim wouldn't challenge it, and so it would ripen into a situation that could be titled. And that was extremely common. And as you might imagine, as California became more populous, it was also pretty popular, so that there was a lot of support in California and Western law generally for squatters, and this is embedded not only in state law but also in federal law. So there'd been, pro-squatting legislation all through the 1830s associated with the Jacksonians, and finally culminating in the Homestead Act in 1862, I guess. But this whole idea that somebody who mixes their labor with the land, improves the land, has a claim of a kind that may in many cases be superior to a paper title which is unimproved, right? So that was, but sometimes as you might imagine, it resulted in litigation and frustration, one side or the other, and sometimes in violence. So there were some famous cases where people were killed and there were shootouts over trying to get rid of somebody who was squatting allegedly illegally. So that was a political issue. In the manuscript, which you can look at, Stephen Field played an important role, partly because in his earlier days in Marysville, in early 1850s, he himself engaged in buying up land in the area, called town lots. And Marysville is located in a Mexican land grant that was owned by John Sutter. That was where he's the Sutter of Sutter's Mill, where gold was discovered. And so Field accumulated a bunch of lots there and was speculating along with everybody else. And early on, and there were squatters' riots in Marysville and elsewhere, and Field was always on the side of the papered titles, however crummy they might have been. So for example, one of the things Field did as a practitioner in Marysville was he set up a recording office, a private recording office. So he offered to record property transactions, not only for himself, but for anybody. So just come to my office, I will file these and have records of them. So Field had an enormous paper record of what was going on in Marysville and later on in Sacramento, as a private source of documentation, right? So Field was definitely on the side of paper as opposed to squatters, and so this is a view that he was critical, incidentally, in vindicating ultimately the Mariposa grant of Fremont. Fremont had lost the initial court case under the previous Chief Justice. When Field came in as Chief Justice of the California Supreme Court, he basically ordered a rehearing, and there was no tangible basis for the rehearing other than the fact that the makeup of the court has changed. That never happens now, of course, but that's what happened. And then he reversed the holding and held for Fremont. Again, it was that the papered property interest was superior to squatting claims. And this was a theme of Field's jurisprudence from the beginning to the end. So anyways, a couple more remarks about industrial farming, so initially there was ranching, all right? Because it was swampland. You could put cattle out there, you don't have to improve anything. As swamps were drained, there was a chance to grow feed for cattle, which was done. Miller and his other ranchers in the area, they grew some feed. After that, but there was a development of canals and canals that would only have to connect immediately to the San Joaquin, which would flow up towards San Francisco. And then soon railroads began penetrating. When that happened, when transportation through the valley became more possible, it became profitable to farm wheat for reasons that are special to California, namely that California wheat could be dry farmed by planting the wheat, in October, basically, and hope it rains. If it does rain, you get a crop. If it doesn't rain, you lose the seeds. So it's a risky deal, but effectively, if land is cheap and if it rains, you're in good shape. California wheat had a special property, which was it's nominally winter wheat because it grows over the winter, but it actually isn't winter wheat of the kind that's grown in the Midwest, because winter wheat of the kind that's grown in the Midwest needs a hard freeze to germinate. California's not going to get a hard freeze in the areas where they're planting, so they planted spring wheat in the winter, but in the virtue of it, it ripened at times when other wheat wasn't available. So it was very favorably positioned in markets. So you could sell, there was a big market for it if you could get it to market. And the way to get it to market is, insofar as canals and railroads were developed, they were able to ship wheats up into the Bay Area and transship in what were otherwise obsolescent sailing vessels. They would take forever to get any place, but they'd eventually get there. So there was a market both in Asia and in Europe and in the East Coast of the United States for California wheat, partly for its own properties, that is, it was particularly good for baking for some reason, I don't know why, but partly for when it arrived in the crop cycle. So that was the second major crop. That period is called the Bonanza wheat period, and it lasted from about mid-1870s or so to almost 1900. And then the next major crop was cotton, and that began to be planted seriously in the Central Valley, in the Tulare Basin and the bottomlands in around 1920, and it became the dominant crop in California in terms of international importance until about 1970. And then gradually other places were producing enough cotton that there was a demand for another crop, and the next crops were basically orchard crops, especially almonds and hazelnuts and pistachios. So that's where we are now. So that's this picture. This is when cotton's being phased out. You see this in wheat also. Almonds, grapes, and walnuts are going up. That's the latter part of the crop cycle. And if you just drive through the Central Valley, you can see it vividly. If you drive right across any part of it, you'll see, like if you drive down Route 5, you'll see to the west side, which used to be basically barren, there's endless almond plantations going in. It's extremely dry on the west side of the valley in the southern part. It's all groundwater. There's no other way to get water there. So that's it. And if you drive across the fertile parts of the valley, like Route 120, which goes towards Yosemite, you'll see what used to be grapes and corn and other things are replaced by almond plantations. So there's almonds are every place now. So the basic story there is that as surface water becomes more difficult and scarce to get, it's more profitable. It's profitable to plant higher value crops. Almonds are an extremely high value crop, partly because they're easy to store. You don't have to send them to market right away, and they're cheap to store. And also they are not, at least in California, the storage is not pest infested. It's not too humid, so they grow well. So at least the current variants. So what's in the manuscript that you have is politics in two kinds, more or less what I call the politics having to do with the squatters idea, Jacksonianism, the idea that people felt that they had a right to a part of the American patrimony for which they'd fought both in the Revolution and the Civil War, and they're frustrated, and so there's this big support for, breaking up these large entities like the Miller Empire. And there was a famous case, and it somehow became believed that somehow this was connected to these two principles of water law, and they thought that, Miller's claim to water in California was based on his riparian rights to water both to the San Joaquin, but also to Tulare Lake, and whatever fed the Tulare Lake, which is the Kern River. The Kern River fed a series of lakes, the Buena Vista Lake, the Kern Lake, and the Tulare Lake, and they were connected through swamps, but basically his claim was there was a river going through it. It was arguable. Anyway, and he was challenged by another very rich person named James Hagan, who bought land upstream and diverted the Kern to irrigate the land upstream, and that impaired it killed all of Henry Miller's cows. In a drought, they just all died. So he sued, and somehow that was thought to be because one principle, that is the riparian principle, was uniquely favorable to the monopolist, that is to Henry Miller. And that wasn't actually true. So what actually was the case was, but still it was politically important, because what happened after Miller's claim was vindicated was an enormous political movement to advocate for the creation of ways in which small farmers and landholders could coordinate against what they called land monopolists. And this was instantiated in the 1870s under something called the Water District Act that authorized the formation of water districts, if people in the area voted to have such a district. And that district would have the right of eminent domain, so it could condemn rights, including riparian rights and pre-existing water rights. And they could levy taxes. And they were governed by a principle of majority rule. That is not by weighted majority rule by wealth, but by pure majority rule, right? This was a revolution as far as the land monopolist, including not only Miller, who won the case, but also Hagen, who was his opponent, because he was just as vulnerable to the water district as Miller was. So everybody who was a big holder of land was vulnerable to the Water District Act. Lucky for them, it didn't work, because it was difficult to finance a water district, because if you try to raise bonds on it, the bondholder might wonder if what happens to the water districts is purely a matter of majority rule, whether or not the person owns property or not, what security do I have for my investment? So they didn't really work very well, but the later emendations of the Water District Act did work much better. And so that ended up being a vehicle by which small farmers would have a chance to stand up against big farms and to some extent divest them of some of their powers. And that was part of the motivation for that. It was a very interesting story about how it happened, but anyway, so that's, okay. So high politics had to do with elite politics, or what I would call the big issues of California politics. Effectively, the big issue in California in the 1850s is slavery. So California was born out of slavery. That is to say, it was admitted as a free state. There were a lot of Southerners here. They brought slaves. There were lots of slaves in California. They tried to work them in the gold fields. That was hard because the miners could see them and would oppose them, but they were every place else, So there was a lot of slavery in California, and there was movements repeatedly in the 1850s to try to divide California into two states, that is Southern California and Northern California, and to regard the southern part as essentially likely to be a slave state. So that was an ongoing feature of that first. And the second thing that was important in California in the first years, aside from land acquisition, what I've already talked about, was clearing the land of Native Americans. So there was you couldn't call it anything other than a genocide. The number of Native Americans in California in 1850 was about, by different estimates, 150 to 200,000. The number of them who were in there in 1900 is about 20,000. And disease did something, but if you read the records, this was state-subsidized killings. The state gave bounties for scalps, all kinds of things like that. So that was another issue in the 1850s. That ended pretty much in the early 1860s, but that was a huge aspect of politics in the early days. So then the next part has to do with the creation of the large water projects. There I set it up by saying there was this demand for irrigation, especially California had a big problem in the Tulare Valley, which is the Sierras are right there. The Southern Sierras, they have these four rivers. They flood typically in the spring. So you'd be large quantities of water, which meant very fertile land, namely the Tulare Basin, was unfarmable because of the floods. So unless you could control flooding, water was very difficult. It's difficult to manage agriculture there at all. And it was difficult to do it privately, although in parts of the valley it was able to control the streams well enough to build private dams. But still, even so, it was difficult to control. So there was pressure to in the 1890s, and so to do something to make irrigation possible by having governmental projects, and that resulted in 1902 with the enactment of the Reclamation Act, which formed in addition the Bureau of Reclamation, but it also provided for programs to finance irrigation. The trouble was that it was set up in a way that made it effectively impossible to run because it required that farmers who got loans for this purpose had to pay them back in 10 years. And that's a really short period of time for major works to be repaired in the farm industry. So basically, and that was the only source of financing. There was no regular appropriation. It was supposed to be funded through a revolving fund, replenished by repayments. So that was how the reclamation, so by 1920, the reclamation program is basically moribund. It's not doing anything. What happened in the 1920s is, in a series of events I'm not going to talk about, it was rediscovered by the Hoover administration, by Herbert Hoover's administration, then by FDR, by Harold Hicks, that the reclamation could be financed in a different way, that is through the production of public power, of electric power. So in effect, it became possible in the 20s to justify the building of projects like Hoover Dam, but also smaller ones, to have the project have a power generation feature that allowed financing without a lot of appropriations. And so the Bureau became, once again, a sort of a place in which they could build projects, and they could build projects of the kind that were valuable in the Central Valley. So they began developing projects. And of course, when they did that, there was a feature of the Reclamation Act that became problematic, which is to say the Reclamation Act forbade the provision of water to holdings of larger than 160 acres. And of course, all the big farms were vastly larger than 160 acres. They were millions of acres, right? So while the big farmers wanted to have the dams built upstream, they also didn't, they also wanted the water that would be behind the dams for irrigation purposes. But according to a strict reading of the act, it didn't seem as possible for water produced behind these dams to be made available to the big farms. So that was a big issue. And so what happened in a short period of time is the farmers discovered, the big farmers found out that, well, there's another agency that builds dams, the Army Corps of Engineers. And they're not, according to the Army Corps' theory, they're not controlled by the terms of the Reclamation Act at all. And so there's no requirement that they be restricted in their deliveries of water to the 160 acres or anything like that. And so the big farms began lobbying for Army Corps projects to displace Bureau projects. And so there's a period that's described in the book about how this conflict played out. In effect, in the short run, there was a truce, roughly in the early 40s, in which the Corps would often build the dam and the Bureau would manage it as a Corps project. And at least according to several commissioners of the Bureau, they winked at the 160-acre limitation. They were willing, under the terms of it, to say, well, it's a Corps project, so it's not bound by this term, even though the Bureau is running the project. Later on, the Bureau, in successive concessions, or revisions of its view, came to the view by the Carter administration that the 160-acre limitation was so restrictive that it was impossible to have, farms in the West by strict enforcement. And so Cecil Andrus, who had been before that a very strong supporter of the 160-acre limit, basically conceded that was no longer interior policy. So in the long run, basically it fell away. So that was the second part. So I want to say a couple things about regulatory models. So the one I haven't talked about much, but I alluded to briefly, is in Southern California, which is the place which experienced the combination of aridity and population pressure very early, especially the San Gabriel Valley, where there was lots of farming, where there were population concentrations in Pasadena, and later on in Alhambra and Monterey Park and other places. What happened in Pasadena in particular had a policy of using rainwater coming down from the mountains above them, Mount Wilson and elsewhere, to recharge the water basin, right? But the trouble is, of course, Alhambra's downhill. And unlike the presumption about groundwater does move downhill, whether there's a stream or not. So the water that Pasadena would recharge into the basin under Pasadena would leak out into Alhambra. And Alhambra would sink wells using the water, right? And so Pasadena sued, and there was a series of litigations. But what it came to ultimately was a recognition that this problem that Pasadena had was not just with Alhambra, but it ran all through the San Gabriel Valley. And I don't know who the judge was, but the judge came up with this policy of saying, well, look, all these underwater rights are completely claimed, so that we're in overdraft. All these basins are overdrafted. So what you need to do, litigants, is you have to sue each other. You have to establish prescriptions against each other. In other words, forget your earlier rights, forget overlying rights, forget any other claim you have on the water. Just file a prescription against everybody, you know. And the presumption of prescription in an overdraft is everybody's harmed by any taking. You do it notoriously, and you come to an agreement not to challenge the prescriptions, which means the court is going to, under a large multi-party structure, decide on some basis to allocate rights de novo, right? And the de novo is basically a rule of proportionality. That is to say, it's going to look at the population, it's going to look at your industry, it's going to have a fact finding having to do with how much water is needed by this or that municipality, this or that farmer, or whatever. So it's ignoring the entire right system. It's basically doing it ground up, right? So that's one mode of regulation. You know, it's triggered voluntarily in the sense that somebody sues somebody for an injunction and doesn't get it, you know, and then the thing ramifies. And then if you're lucky, as was the case in Pasadena, there's a judge who's creative enough, or maybe lawyers who are creative enough, to put together a large multi-party negotiation. And it took years, it took like 10 years to come to this. It's called the Raymond Basin Reference. And it was sufficiently successful in Pasadena that it became the model for, I think, 6 or 7 other basin adjudications in Southern California. One of which was on over near Santa Monica, where they had an additional problem of saltwater incursion. Also in Orange County, again, saltwater incursion, but there were other ones inland, and they all had the same form. They all were established mutual prescriptions, you know, and then have the judge supervise a negotiation in which essentially water rights are distributed more or less proportionately to whatever the basis for proportion is. What's interesting about the water basin litigations, there's 2 things. One is, some people theorize that as, oh, that's voluntary negotiation. It's not that at all. The judge used coercion in various important ways. Basically, he said, if most of you agree, I'm going to enforce it on everybody. There's going to be an agreement. You better be in the room rather than outside. And that worked pretty well. But he also insisted that the state water agency, the witnesses were provided, you know, in various ways. And so he used the existing bureaucratic capacity in Sacramento to actually assist in the formation of these proportionality rules, because he didn't have a basis other than that. He had, the water agency provided an administrator, which is called a water master, to run the program, to basically figure out what was proportional. The judge is not an expert in that. So this is experts from the state agency. So it wasn't really voluntary. It's an agency that was judge supervised, but which was administrative. That is, it involved the capacity of the water agency to basically provide expert witnessing to come up with a proposal for how water rights ought to be allocated. And that worked in all these basins. So that's the adjudication model, right? So you might think that, you know, but these all took a long time, especially the Raymond Basin one took 10 years. The other ones took a little bit less because Raymond Basin already happened, so people knew how it was going to go. But, you know, still, it's an unwieldy process. So the question is, why doesn't the state agency take the lead? Why doesn't it inaugurate, not adjudications, but, you know, some way of coming into a basin where there's a problem, like the Tulare Basin, for example, that basin, the one where the water levels are plummeting. Why can't the state agencies come in and say, oh, we're going to figure out a way to regulate water rights here, you know? And it turns out that there were, soon after the Raymond Basin situation, or maybe during it, there was legislation introduced to forbid that from happening. You know, the landowners did not want the water agency, the state water agency, to have the authority to initiate a reallocation or an allocation of water rights. They wanted to preserve the rights they had, especially the rights to underground water. So that's the state of an alternative mode of regulation. It's making a comeback under the Brown administration. There's an effort to manage groundwater that's been put in train. It made concessions to the local interest, the big farms, basically, by saying it should run through the water districts or something like water districts in each basin. Nowadays, because of the way the science has evolved of hydrology, there's thought to be about 500 distinguishable basins in California, so that means there's supposed to be 500 separate plans. The distinguishing feature of water districts now, as opposed to water districts when they began in the 19th century, is they're mostly captured. Either by one big landowner, like the Kern, like the wonderful company in Kern, or Westlands, which is a bunch of people, but it's not small people. So it's a concession to say that these water plants have to be driven through entities which are basically mostly controlled by local large landholders. But they also have a role for the state to say it's got to be an acceptable plan, and the default is the state can step in. And we'll see how far that goes. I don't think we know yet. These plans are now at the point when they're supposed to be going into effect more or less now, or the last couple of years, I think. So we'll have some experience of that later. We just don't know how well that's going to work. So at least there's some reason to think that there's going to be some move at the state level to do more regulation of groundwater that may or may not work. The second move that's happening is quote unquote voluntary. And this is something that happened as a result of what is called the Monterey Agreement, which was a negotiation, who did it involve? State, federal, other entities. And one feature of the agreement that happened in 1994 was a swap between Paramount Farms, the wonderful company owned by Stuart and Linda Resnick, of their water rights in the Central Valley for control of the Kern Valley Water Bank. The Kern Valley Water Bank is a bank in two senses. It's an accounting device for water, but it's also a physical vault. That is to say, it's an underground aquifer, which has been largely exhausted and rechargeable. Right? So what happens now? The Resnicks have used their ownership of that bank now because they got the rights to own that bank. They've developed the bank to be a workable vault. They now have 4 years of storage, 4 years of their usage underground, right? So what that means is they have a huge farm to grow almonds and other things. And so they have 4 years of what they could use underground, but what that means is they now sell water to Southern California, and so they sell when the price is good, which is when dry years, and they buy when the price is good for them, which is in the wet years. So they buy water from the water projects. So that's another development which, may in the long run have, it's a private sector development, largely, at least after the swap in the Monterey Agreement. And it may be a way in which there's amelioration in places where there are large farms that can actually manage these. So I think the Kern Water Company is not the only one like this, or I think there's 4 or 5 others in this Tulare area, maybe more than 4 or 5. And it may be a way forward because it is a way to make a profit from the fact that you have storage capacity, and there is storage capacity underground. I'm going to stop there.
Okay, thank you.
We got 20 minutes?
You can sit down and listen to Phil if we've got Phil. Do we have Phil on?
We have Phil, yeah.
Okay, let's go to Phil and then to Roger. Okay, you're on, Phil.
Great. Well, thank you, John, for the presentation. I'd like to thank the Land Center and Bruce for inviting me to share some reflections on John's book on Californian politics of land and water. And I wish I could be there in person, but I made travel plans before I learned of the event. So I'm glad that I'm able to join today by Zoom. So since I'm not a historian, I'm trained in law and hydrology, and I mostly work on issues of modern water policy. I'm going to primarily focus my comments today on what I see as some of the contemporary relevance of the historical analysis that's in John's book. And specifically, I'd like to offer observations on 2 different topics. The first being speculation and anti-speculation efforts in land and mostly in water. And second, on the legacy of 19th and 20th century land and water politics today in the form of systemic inequities in California water rights. And I'm going to aim to keep my comments to about 10 minutes here. So starting with the issue of speculation, I wanted to elaborate a core tension that's documented in the book, this being the tension on the one hand between the longstanding historical ideology, John labeled this the Jacksonian ideology of America as a nation with small, relatively equal, dispersed farmers and without excessive wealth inequality. That vision versus the frequent reality of speculators or monopolists who assembled large land and water holdings. And so John's book traces this tension between these two ideas from the earliest days of the United States through California's cession and statehood, through Civil War politics, and then through the Reclamation period. And he argues that efforts to achieve the Jacksonian ideal, particularly in the Western United States and in California, have repeatedly failed, and that this ideal has become something of a zombie idea. And at one point in the book, he says that, quote, "It took obtuseness to believe that the immense arid areas of the West could actually be settled by the small family farmer, but even sophisticated political leaders and bureaucrats shared this ideological belief." And so in the specific context of appropriative rights systems governing mining and then water, the book says that, of course, the egalitarian aspects of the codes became an irrelevance and, more important, a nuisance, and the Jacksonian ideology did not simply disappear without a struggle. And so this seems like a core argument in the book, that these Jacksonian anti-speculation policies were ignorant of the political economy of land and water in the West and in California, and were impractical to administer in many cases, and for those, among other reasons, that they failed. So this historical analysis of California differs quite a bit from historical analysis that's been done in another state where I've worked a lot, which is the state of Colorado. And specifically there, the legal historian David Shore, who's written a book titled The Colorado Doctrine, describes the development of the prior appropriation doctrine for water as what he calls a radical attack on corporate power and monopoly power in the Western United States. He argues that, at least in Colorado, that miners, irrigators, lawmakers, and judges formed a private property system in water rights and anti-commons that was based on a desire to spread property and its benefits widely, and to avoid speculation in water based on land ownership. And he also relays how the appropriative rights system intentionally adopted key rules designed to curb speculation and monopolization of water resources, those being rules like limiting the measure of a water right to its actual historical use. These are various use it or lose it type policies or rules that are in our in aspects of Western U.S. water law, as well as the anti-speculation doctrine, which requires that new water rights or transfers of water rights to new uses, that those show sufficient specificity in terms of where water is actually going to be used afterwards. And Shore also argues that that economic efficiency was not the primary goal of prior appropriation. Instead, he argues that the goal was to maximize the number of appropriators and limit the size of appropriations. And in a topic that's pretty relevant to a lot of my own research, which has been on water markets in the Western United States and in the Colorado River Basin, Shore argues that a key example of this aversion to economic efficiency was found in trading rules governing water transfers under the appropriative water rights system. And so, for example, under prior appropriation, and this is true in California and in Colorado, Colorado's law on this point is actually drawn from California Supreme Court decisions. Water transfers may only occur if they cause no injury to other water rights. This practically means that they can't cause any reduction at all, full stop, in the water that's available to other water rights. And this rule can dramatically raise the non-water transaction cost associated with doing water transfers, which makes it difficult to trade water or adapt water use in the 21st century, and impedes development of water markets. And so while many economists have argued over the years that rules like this were just a historical oversight, there's actually ample historical evidence that suggests that that more efficient trading rules were considered but rejected in the 1800s, again, kind of in service of at least these aspirational goals of curbing speculative behavior. And so there's this argument that, at least in the context of the state of Colorado, that the appropriation doctrine successfully curbed the power of corporations and speculators. And so after reading John's book, I'm left wondering whether these two views of appropriative rights systems can be made compatible, or if California is really just that different from other Western states. So California is, of course, a different legal and geographic environment than the Intermountain West or Colorado. John discussed earlier how riparian rights were retained in California. They were not in other states like Colorado. He also discussed how Mexican land grants created legal uncertainty for land and water rights ownership, and both of these items provided openings for speculative behavior. He also talked about the immense scale of some agricultural operations in California in the past and recently. The crops grown in California tend to be higher value, quite a bit higher value than the lower value crops that are grown in much of the rest of the arid West. And California's agricultural sector and water markets are decidedly more corporate than those of other Western states today. So maybe the political scale economies that the book talks about have driven development of California land and water policy in a way that those scale economies are just lacking in other parts of the West. Or, perhaps some of the arguments or evidence that have been presented in other states have been overly drawn from a legally formalistic viewpoint and have been insufficiently grounded in legal realism. The legal realism in John's book is something I really enjoyed. Certainly in the early days of water rights in California and anywhere in the West, water rights were in some cases greatly inflated and corruption occurred, which yielded larger water rights. But maybe there's also a unifying theory here that joins the empirical analysis that's in John's book, focused on California with competing experiences from other states, and that explains why the Jacksonian ideal was politically in some ways doomed in California, but that it may have achieved some of its objectives in other states. Either way, sort of unifying theory or not, we've inherited today a water rights and allocation system that has entrenched rules that make it difficult to adaptively manage water supplies due to rules that were originally instituted with at least the aspiration of curbing speculation. And so the analysis that's in the book, and then others have done on the topic of anti-speculation underpinnings of our water rights systems in the Western US, these aren't just matters of historical debate. These are important for modern policymaking, since in recent years, there has been backlash in some parts of the Western United States against financial speculation by, for example, investment funds of various kinds in water rights and in water markets. And so in states across the Western US, including in California, in Colorado, and in Washington state, legislation has been proposed and studied to curb financial speculation in water rights because investors have generally acquired farms and then continued using their water rights to run them as farms. Sometimes they'll look to eventually profit by selling or leasing those water rights. The anti-speculation elements of water law, which are focused on putting water to beneficial use, have not stopped such investments. However, some policymakers and water users have called for doubling down on anti-speculation policies and would add new restrictions, for example, taxing financial gains from certain water transfers, to try to discourage such speculation. And so similar to some of the flaws around administrability and political flaws that are in the book, that kept past policies like acreage limits from limiting speculation in California, these new proposals have so far had trouble getting off the ground. And so, for example, in Colorado, the state legislature created a working group to investigate how to strengthen current anti-water speculation law. But after about a year, at least, of meetings, That group could not agree on what counted as speculation. They couldn't agree on why it was bad for private investors to sell water for profit while relative to other water users, or how to generally regulate speculation. And so if this type of financial speculation is to be guarded against, and I have not yet been convinced that it should be, John's book warns how any efforts along these lines must not ignore the political economy of land and water management. And the broader point here is that the Jacksonian ideal that is central to the book is to still some extent alive and driving policy initiatives to allocate water today. And the critiques in the book of past efforts to implement that ideology in California seems relevant to me to those efforts. So I have comments also on systemic inequities in California's water rights scheme. I'll try to keep these brief. So a topic that has received significant attention in the last few years, both in court filings and in legislative hearings, is systemic inequity and racism and its legacy for California water rights today. And although it's not necessarily a stated objective of the book, John documents in detail how non-white races were systematically excluded from gaining access to water, land, and mining rights in the 1800s. And so there are a number of quotes I could share here. John already shared some of those earlier. And as he and others point out, politics and law merged to create water rights systems that were intentionally designed to resist change. And so that, combined with the documented history of systemic racism and early water allocation in California, is important because it differentiates discussions around these systemic inequities in water versus in other property regimes for other resources. And so, in other words, unlike some other property regimes, water rights regimes arguably face more internal resistance to change to overcome these legacy inequities. And so overall, this book can be an important supplement to ongoing discussions around systemic inequities in water rights systems. So with that, I want to thank you for humoring and tolerating a scientist's thoughts on a history book. And I look forward to the discussion. Thanks.
Very good. Thank you, Philip. Okay, Roger. You go up there.
I was amazed at how well written this is. I mean, this is really good. This is cool. I love it. And so now you all should know is that John is writing from a deep bias. And the deep bias arises from the fact that every year, several times, he drives back and forth across the Central Valley. And right in the middle of the Central Valley, there used to be a terrific little stand that sold the fruits and vegetables, and it was run by a woman who went to college with his two elder children and even played in the Cal band with them. But 4 or 5 years ago, they tore out the fruits and vegetables, closed the roadside stand, and planted almonds. And he's getting even. Now, I might add, because the person who runs the farm is a Cal graduate, highly educated, and is not exactly the populist idea of a small farm. It isn't a small farm. So this is a land monopoly that he's after. So, so let me go through. I had relied upon Phil incorrectly to talk about one of the underlying themes in the book, which is an implicit assumption that the state of technical knowledge about hydrology is pretty much the same through history. And so the very first point I think that's important is Western water policy throughout the 19th and the first half of the 20th century was premised on false theories of the underlying hydrology of the entire region. We see it in the Colorado River Compact. We see it in Phil's home state of Colorado, which had a governor in the 1870s who espoused the rain follows the plow theory. And we find the same thing in California. And what we have, one way to interpret some of John's history of how things evolved in the Central Valley was the easier issue to learn about was whether your ideas about surface water were correct. And that's where the ideas about storage and groundwater recharge and things like that come from, managing the surface water. And that was, so we knew by the end of the 19th century that rain follows the plow wasn't right. We knew fairly soon after the Colorado River Compact that it was based on a false premise of how much rain there was on average in the Rocky Mountains. We knew that the premise behind the acreage allotments in the Dakotas for wheat farms was based on a premise of more rainfall than would actually happen. So you couldn't really farm, do dry farming in that part of the country, even though people thought you could. So part of what's going on is a learning effect, that the system of water rights and land rights and allocation is changing over time in response to improved information about how to do water. The problem about groundwater is it isn't as easy to understand. And indeed, even today, it's not fully understood. And that's part of what the story in the book is about how we don't really understand it. But the knowledge is improving. This is closely related to the institutional story he wants to tell, because institutions are a kind of what we call putty clay capital investment, right? That is to say, you design an institution to solve a problem, and you sit there and let it work away solving that problem. It hardens into something that becomes extremely difficult to change, because as John argues, the American political system is designed to make change difficult, to make it slow, to make government not be an important source of risk. Now, recent innovations in American politics have caused that risk to reemerge, but still, what's going on here is institutions that, because knowledge is improving, are becoming less and less well-suited to solve the problem of the day, but they're difficult and costly to change. And so I think the match of the institutional redesign problem to the changes in the underlying knowledge about the technology really is an interesting additional story that would help John explain some of what's been going on. So that's part one of the story. There is a connection between technical knowledge, institutional design, and the inability to solve quickly problems that arise when ignorance is discovered about knowledge. The second important point, I think it seems to me, is tied up in John's willingness, even though he used quotation marks to do it, if you can see in his slides, whenever the term monopolies is used, it's in quotation marks. And that's because he fully knows, well, these aren't monopolies, right? We normally think of monopolies as things that have market power, that unilaterally can affect the price of either an input or an output. That's not what these institutions, these organizations are. These organizations are basically a profitable and useful things to try to do only if there's some serious source of economies of scale in the underlying industry. So the question then is what is the source of economies of scale that would mean that the way the Central Valley land and water is going to be allocated is going to have a tendency to be a smaller number of large holdings rather than a larger number of small holdings. And that interesting question about what is the source of the economies of scale strikes me as having a serious political component. As John says, he says there are economies of scale in dealing with the political system. Yes, and that political system has been constructed on purpose for a reason. And what is that reason? And one can interpret the combination of the way the water rights are defined in terms of timing of use, the way riparian rights are defined, the way the prescriptive rights are defined and enforced, as a mechanism where the initial allocation of rights is going to have an egalitarian focus, but then the permission of violating those rules through transactions becomes a mechanism whereby the rents available from economies of scale get more widely distributed in the form of higher land values that then a small landowner can capture some of the benefits of the economies of scale because the market price of the land goes up to reflect its best use as opposed to its use in a small landholding. That would be the mechanism by which, if there were a Coase theorem type world here, where there were a market system without impediments, without any market failures in it, one would predict that economies of scale, whether institutional and political on the one hand or purely technical on the other, large farms have higher yield per acre on average than small farms, some combination of those two would be the facts that determine what the value of the land is, and then the institutional rules about settlement and settlers and allocation of water rights would be a mechanism for distributing that in the population. And the Jacksonian revolution can be interpreted in two ways. One way is purely through the lens of Coase, let a large number of people go and squat land and then lease or sell it to some big person, and they sit and collect the incremental value by the lease value or the sale value of the land. Or alternatively, which is the political way it's packaged, it could be a lifestyle. And if it's a lifestyle, that's a kind of market failure that can never be captured in a market. And so, is it really just the first, or is it also the second? We have a former student who can answer that question for us. And if somebody that Phil knows, that Elizabeth Hoffman.
Oh, and she's out of a job.
She was former president of the University of Colorado, but she wrote her PhD thesis on the Colorado River Compact. And do you remember what happened to her when she proposed the idea of a market mechanism for allocating water rights to the Imperial Water District?
I don't remember what happened.
She went down, she did an interview with these people to explain to them how wonderful the world would be if we had tradable water rights in the Imperial Valley, and as she left town, they shot at her. They didn't shoot to kill, they just were shooting warning shots. But therein lies, I think, the crux of the issue. Do we want to have a populist allocation of the initial rights followed by a market process to capture the economies of scale that has the property it equalizes the distribution of wealth, but it doesn't end the concentration of control of land? All right? Or what we really want is to preserve the character of rural communities which don't, it's sort of like the argument on having a Walmart move into a city of 20,000 people in the middle of the Midwest. It fundamentally changes the character of downtown to have all those small stores be replaced by a Walmart. Is it purely about the efficiency of retail sales, or is it also about the kind of society that arises? That strikes me as the core issue in the politics of land and water, not only in California, but throughout the country. So, one last point, then we'll be done. I thought the singularly most interesting thing I learned from reading the book was the story of the evolution of irrigation districts. And I would almost make that the centerpiece. This is just me, obviously, because I don't have the same angst about Fisher Farms that you do. But the key point about irrigation districts is that this became a solution to the collective action problem and coordination problems for essentially taking into account the public goods aspects of water reclamation and exploitation, the exploitation of a water resource. It is a mechanism where this evolution of the voting rights was trying to get at was how do you do this trade-off between the egalitarian purpose and the preservation of community, which argues in favor of a purely democratic mechanism of making decisions about the allocation of water rights and the exploitation of the resource, versus voting based upon the value of the land and the amount of land holdings you have, which is oriented towards capturing the technical scale economies. One can interpret these water districts, if they get large, like Westlands, as a mechanism for trying to reach that trade-off, because in Westlands, yes, 10 large farms can control the boat, but 10 large farms also have conflicts of interest among them. And it's not clear that 8 of them won't want to form a coalition with the little guys instead of the other 2 big guys. And so that, I think the whole idea of how you design a water district to capture these 2 values of the pure maximization of land value versus the preservation of community. Now, having said that, one of the major issues, and I suggest you read, there's an article written by a Stanford PhD of about 40 years ago, and now teaches at Carleton College, on the importance of the groundwater versus surface water subsidy in determining the allocation of crops. And his finding is that the value per acre of the water subsidy is all in, first of all, the water subsidy is intramarginal. The marginal water is the groundwater pumping. So when you talk about economic profit maximization, it's always going to be the cost of the groundwater pumping that determines precisely which crops you plant and how much land you use. The subsidy for the surface water is less than the value of the land, which means that you can capture the entire surplus through market-based pricing, and you wouldn't change the crop allocation. All right, in other words, his argument is the distribution of crops and the size of agriculture and the kinds of crops you grow, the technology you use in growing them, and the distribution of farm size is unaffected by the subsidy, because the subsidy is small compared to the value of the land. And that suggests that we have a whole lot of wiggle room in designing the institutions. There are lots of institutions out there for allocating what the rent in the land can be that have no effect on anything real. All right, and if that's true, then the politics ultimately is nothing but a distributive justice policy. It has nothing to do with economic efficiency. And anything you impose to get in the way of that prevents the water districts from making these decisions runs the risk. All it will do is destroy the efficiency without any gain. So this strikes me that that's again an interesting thing to pursue on explaining the way that irrigation districts came into existence and how they were formed, is that it's really all about how you allocate the rent, because nothing you really do is going to affect the magnitude of the rent, unless you prevent large farms from happening at all. Okay?
Okay.
I want to thank both Phil. Is Phil still here? Is Phil still online?
Yes, he's still online.
Oh, thank you, Phil. Thank you, Roger. I wanted to say one thing that I thought was kind of in between Colorado and California, Utah. Roger knows a lot about Utah.
I have some Utah notes that I can do.
But what's interesting about Utah in the same period that when, in the late 1800s, is that I guess, they managed a system of relatively small farms, and they had similar water problems, and it was managed mostly through the instrumentality of the church, I think. And so the maximal land holdings were, on the order of 30 or 40 acres. I mean, quite small compared. Now, this is a pretty fertile part of Utah, around Provo or these places, but still social structure, governance, if you want, to actually manage things different than what happened in California and different than what happened in Colorado. So it seems like an interesting story, which, yeah.
That's exactly right. They had a theocracy.
But I also want to agree with what you said. I think no matter what's going to go on in California, because of the way water pricing, the value of water is changing, the marginal value of deep water is what drives everything. And that means anybody would plant almonds. You'd be crazy, whether you're a big farm or a small farm. Of course you plant almonds. For all I know, the fishers planted almonds. I don't know about put the almonds in there. So I agree completely that there's a kind of neutrality principle going on here. That is, the economics tell you plant almonds or pistachios, and whether you're big or small, that's what you do. That's an efficiency issue. But this other issue of what kind of a community we're going to have, I think that's really at the center of the water district. At least it was at the beginning. And Roger didn't say this, but at the end of the story on water districts, during the period of the Voting Rights Act, 1965, the Supreme Court had to decide whether or not these irrigation districts were subject to the Voting Rights Act, right? And so the Rehnquist court, as luck would have it, was what handed down the decisions, which they said, oh, these are not like, general purpose counties or anything like that, so they're not subject to the principles. So they can regulate things by wealth holdings. But that meant something for the way the communities were going to be organized in those places. It may have not affected the efficiency calculation, but it may have affected the structure of community life in the towns in the Central Valley. Probably did. So anyway.
Okay, well, listen. This was an excellent presentation on all three of the speakers' parts. This is the kind of thing that we need to be doing more of. I'm preaching to Dick Luthi and the hydrologists. We really need to be looking into the institutions and the policies because they have an enormous impact on what we see in terms of the water system we have. Notice that the political scientists and the economists mention nothing about the problems, the long-term problems, climate issues that we have and how that affects.
Well, that was in
yeah, I was in
the book.
Okay. Well, okay.
We only talk about things we disagree on.
Yes, exactly. But you know what? These two, we're going to have another 2 hours of this. We're going to dinner, and so they will continue this discussion. But it's that these are the things that we need to be doing more of at Stanford. So I really appreciate my two longtime friends and colleagues for doing this, and to Phil, excellent job for bringing up the comparison. I think that opened up the discussion quite a bit. So thank you to everybody online and to the people that have come here. Thank you very much.